But the fate of the Justice Department and the rule of law was a little bit in question, too, right? How would the court deal today with the crisis around this case, right? The president publicly demanding that the sentencing recommendation from prosecutors should be thrown out, that Roger Stone was being treated unfairly and that he shouldn't get any prison time. The attorney general then apparently acceding to that request and getting himself into that case personally, overruling the prosecutors who had brought the case to instead ask for lenience for the president's friend, for Roger Stone. I mean, the trial team, all four prosecutors, all quit this case in protest when Bill Barr did that. Today's the day that we're going to get some sort of reckoning for that, right? How's the judge, how's the court going to handle it? How's the U.S. Attorney's Office, the prosecutor's office that just got rolled here, right? That got overruled by the Attorney General and all their prosecutors quit in response. How is that office going to deal with that, standing in front of the judge today, having to explain what happened and how they've dealt with what Bill Barr did to their case, which he came in and took over? Well, I really didn't know heading into the proceeding, but I did not think it would go like this. All right, this is a conversation at the hearing today between John Crabb, who's the prosecutor belatedly installed in this case after the trial team all quit. It's a conversation between John Crabb and the judge, Judge Amy Berman Jackson. Your Honor, I want to apologize to the court for the confusion that the government has caused with respect to this sentencing and the difficulties surrounding that. I want to make clear to the court that this confusion was not caused by the original trial team. The original trial team had the authorization at the U.S. Attorney's Office to file this sentencing memorandum that they submitted to the court Monday before last. The judge. Let me just follow up on that. So the trial team wrote it? Mr. Crabb, yes, Your Honor. The judge. But someone higher up than them had to approve it. Mr. Crabb, correct, Your Honor. The judge, does that include you? Mr. Crabb, I was part of the process, Your Honor. The judge, all right. Did it go all the way to the U.S. Attorney? Mr. Crabb, yes, the U.S. Attorney reviewed it, Your Honor. The judge, did he approve it? Mr. Crabb, yes, Your Honor. The judge, and did the U.S. Attorney's Office for the District of Columbia then have to get approval from Maine Justice before it was filed? Mr. Crabb, I don't know the exact requirements. I know that there was consultation between the U.S. Attorney's Office and Maine Justice. The judge, did they receive the approval from Maine Justice before they filed it? Mr. Crabb, no, Your Honor. My understanding is, based on what the Attorney General has stated, is there was a miscommunication between the Attorney General and the U.S. Attorney as to the authorization and the expectations that the Attorney General had. The judge, but it was approved by everyone whose name was on it, including the U.S. Attorney. Mr. Crabb, yes, Your Honor. The judge, can you elaborate? Do you have any personal knowledge about what the nature of that miscommunication was? Mr. Crabb, no, Your Honor, I don't. The judge, you're not suggesting now that anything that was in the first filing about the nature of the offenses or the calculation of the guidelines or the evidence in the case was incorrect, are you? Mr. Crabb, no, I'm not, Your Honor. Mr. Crabb, the other point I would like briefly to address is I would like to state, and I would like to emphasize this, that the original sentencing memorandum filed by the trial team was done in good faith. Reasonable minds can differ as to what an appropriate sentence may be, but as the court has alluded to earlier in this proceeding, it's generally the policy of the U.S. Department of Justice to request guideline sentences. There was nothing in bad faith about what was done by the original trial team here. The judge, well, it's not just a question of whether it was good faith. It was fully consistent with current Justice Department policy. Isn't that true? Mr. Crabb, yes, Your Honor. The judge, the current policy of this Department of Justice is to charge and prosecute the most serious offense available in order to get the highest level guideline. Isn't that correct? Mr. Crabb, that's the general policy, Your Honor. The judge, and I have been told by assistants standing before me that they aren't even allowed to recommend or agree to a sentence below the guideline range without supervisory approval in your office. Is that correct? That's correct, Your Honor. The judge says, all right, continue. Thank you, Your Honor. The other point I would like to briefly address, Your Honor, is the Department of Justice and United States Attorney's Office is committed to enforcing the law without fear, favor, or political influence. This prosecution was, and this prosecution is, righteous. The defendant, Mr. Stone, was found guilty by a jury of his peers of committing serious crimes, obstructing justice, lying to Congress, witness tampering. We believe that based on those crimes of conviction, the court should impose a substantial period of incarceration. The judge, all right. Now, with respect to the second filing, your name is on that, and you're the one that signed it, physically signed it. So does that mean that you wrote it? Mr. Crabb, Your Honor, I'm not at liberty to discuss the internal deliberations and how materials are prepared within the U.S. Attorney's Office or the Department of Justice. But the court's right. I did sign that document and submitted it. The judge, well, were you directed to write it by someone else? Mr. Crabb, Your Honor, I apologize. I cannot engage in these discussions of internal deliberations. The judge, all right, is there anything else you want to tell me about why I should impose a substantial period of incarceration in this case? Mr. Crabb, nothing more than to reiterate that this is a righteous prosecution and the offenses of conviction are serious, as has been set forth in more detail in the original sentencing memo. Mr. Crabb, Your Honor, the last point I would like to make is that under the unique facts and circumstances presented in this matter, this is amazing. He says, quote, it is particularly appropriate for the government to defer to the court with respect to what the specific sentence would be in this case. We understand that has happened in all sentencings that are adjudicated in this courthouse, that the court will consider the entire record in this matter. And most importantly, that the court will rely on its own sound judgment and experience. To add to that, Your Honor, given this court's unique experience with related cases before this court and this court's record of thoughtful analysis and fair sentences imposed in those cases, the government has the utmost confidence that we defer to the court. We have confidence that the court will impose a just and fair sentence in this matter. So after all of this, after the worst rule of law crisis in an administration and in a presidency that is a walking, breathing rule of law crisis, after the president denounces this prosecution as a witch hunt, the president demands that the prosecutors are somehow criminal themselves for recommending a strong prison sentence for Roger Stone in this case. After the president attacks the jury in this case and attacks the judge in this case. After William Barr hears that public criticism from the president and intervenes and rescinds the sentencing recommendation from the prosecutors running this case and instead says, no, I, William Barr, insist that instead we have a revised sentencing recommendation that says that Roger Stone should get off. After all of that, when the U.S. Attorney's Office, the deputy head of the criminal division in the U.S. Attorney's Office in the District of Columbia, when John Crabb has to stand up in front of the judge and explain and justify what has just happened, he basically says, you know what, Your Honor, everything that you have heard from the President of the United States in this case, we disavow. And everything that William Barr did and everything that William Barr made us write in that second memorandum that, yes, I signed, but I don't want to talk about it, everything in that we disavow. Our prosecutors who had to quit this case in protest, they were right. This prosecution was righteous. Stone ought to go to jail. And, Your Honor, you're a good judge and we trust you to do what's right. I am glad there are not cameras in courts. For a million reasons. Today, I am particularly glad because today, someone in a position of authority in that U.S. Attorney's Office that has been absolutely rolled by this president and by this attorney general, somebody in that U.S. Attorney's Office stood up and said, no, not before a judge. I can't do it. Just incredible.
Hey there, I'm Chris Hayes from MSNBC. Thanks for watching MSNBC on YouTube. If you want to keep up to date with the videos we're putting out, you can click subscribe just below me or click over on this list to see lots of other great videos.